topics and opinions expressed in the following show are solely those of the host and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good morning, Florida, my home state. Welcome to another Ask the Experts radio show. Hey, this is our 16th year, and I got to tell you, our expert who's with us today, we got so many questions from you to ask Attorney Tom Olsen. And when I first started doing the show with Attorney Olsen, I said, God, this guy is really good for his first two shows. And then I find out he's had this long-running radio show. He's been doing this for so many years. We're talking about estate planning today. Good morning, Tom Olsen.
Good morning, Steve, to you and all of your loyal listeners out there. Yes, I am the host of the Olsen on Law radio show, America's longest-running legal radio show. This year, I celebrate 40 years on the radio, answering legal questions for people. You can listen to it on the internet at WDBO, or I also turn it into a podcast. It's called Olsen on Law Radio Show every Saturday at 11 a.m. on WDBO.com.
Wow. And the name is Florida Senior Planning. So that means you cover all Florida, and we've just changed the show from South Florida because your show is so popular to cover now all of Florida. I think it's so exciting, but I love the name Florida Senior Planning.
Thank you, Steve. Yes, we assist clients throughout the state of Florida, from the Keys to Pensacola. We help them with estate planning. We help them to avoid probate. We help them to protect their wealth from the cost of a nursing home. We help them with the Florida waiver program that will provide up to 30 hours per week of free in-home care for seniors, light cooking, light cleaning, activities of daily living, taking you to doctor's appointments. So if you're like most people, you want to stay in your home as long as you can, this waiver program, 30 hours of free in-home care, is going to help keep you at home.
Tom, I got to tell you, we do so many different areas of law around the country. But I have to tell you, when it comes to estate planning, you've got to have a certain heart to become an estate planning attorney. I say the number one thing is you've really got to care about people. And now with doing the show as long as we have, I really see that you've got such a heart to help people.
Thank you, Steve. I've been a lawyer for 45 years, and I've been doing estate planning that entire time. Way back in the day, Steve, I actually practiced law with my father. We would do divorces and we would do bankruptcy. We would do criminal defense, but I turned out that I did not like those areas of law. I like to focus on estate planning. We get to deal with happy clients, Steve, and when clients come to see us, together with the client, we will come up with an action plan. What is the best plan for their estate planning? We will quote them a flat fee. So, Steve, I don't have to keep track of my hours. Everything I do is on a flat fee basis. I get to deal with happy clients, and it's such a satisfaction, Steve, because often when the clients are done signing their estate planning documents, they'll feel like they've got a weight off their shoulders. They'll say, oh, I'm so glad that I finally got this done. Believe me, folks, The process is very simple. You contact floridaseniorplanning.com. We're going to make the process simple for you to get your estate planning done, make things simple, easy, inexpensive for your kids when you pass away. Not only are they going to save money, it's going to save them from arguing with each other when they pass away. Steve, I see that happen so many times these days when people have not pre-planned their estate plan.
You know, Tom, people see the word estate with estate planning and they think you have to be a multimillionaire. And that's just not true when it comes to estate planning.
It's not true at all, Steve. In fact, I'm going to say the people that have less money, their estates are often more complicated than the people that have more money. But when we talk about avoiding probate, somebody might say, you know what? I've only got $10,000 in the bank. What do I need to worry about avoiding probate? Well, our minimum probate fee is $4,800, Steve. So if you say, I'm not going to worry about that $10,000 bank account, I'm going to let my kids worry about it. Well, are you prepared to get half that money to the attorneys and court costs for your kids to get $10,000? They got to spend $5,000. No, we don't want to do that. We want to avoid probate on that $10,000 bank account so that when you pass away, all your kids need to do is show the bank your death certificate and they'll turn the money over to them. No probate required. So, Steve, I would say no matter what the size of your estate, it is proper and important for you to do estate planning. The 4 basic documents: will, living will, pull the plug document, healthcare surrogate, financial power of attorney. Take the easy steps to avoid probate. No matter what the size of your estate, even if you don't own a home, we should do estate planning for you.
Tom, we've got some letters here that came in, and the first one is from Gabe in Fort Lauderdale. I don't know if it's a male or a female, but it says, on assets, if you have beneficiaries assigned, does that take the place of a will, or do you still need a will?
So, Steve, when we do wills for people, standard procedure, we always do a will. But let's say that I do a will for a client and she has 3 children. Well, if we take all steps necessary to avoid probate, what her will says does not matter, because what's happening to her assets is not governed by her will. It's governed by how she filled out the beneficiary designation forms on her IRAs, 401ks, life insurance, and annuities. How the client made her bank accounts, POD, payable on death to their kids. Who she named as a beneficiary of her home, who's going to get her home when she passes away, avoiding probate using a ladybird deed. But even when we take all steps necessary to avoid probate, we still want to have a will. It's still a safety net. It's there just in case an asset is found out even after you pass away, that you did not take steps to avoid probate on it.
I've never heard this before. Transfer on death. Do we still need a will if we have a transfer on death?
Okay. So when we talk about bank accounts, checking, savings, CDs, money market, investment, non-IRA accounts, it is easy to avoid probate on those by making those accounts POD, payable on death, TOD, transfer on death, ITF, in trust for. Those are all terms to use to avoid probate on your bank accounts. Different banks, different credit unions, different investment companies use different terms. Most common term is a POD, payable on death. But if your bank wants to use a TOD, transfer on death term, that is fine. It's the same thing. Just depends on which bank or credit union you're dealing with. POD, TOD, they're the same thing.
Here's, I don't know if this is quite your area or not. This is from Nancy in Orlando. She said, I love your show. Thank you for all your valuable information. I heard if you get an EIN, isn't it better to set up a bank account this way versus opening up a bank account in your name? If you set this up as a trust, how do you direct deposit and how do you report it on your taxes?
Okay. There's a bit to unravel there, Steve. So let me see if I can explain it in a way that people can understand it. Even when you hear people talking about trusts out there, they're all talking about the same thing, a revocable living trust. It is a tool to avoid probate on assets for the purposes of taxes, income taxes, etc. A living trust is tax neutral. It's not good, it's not bad, it is neutral. As long as you're alive, all of your bank accounts may be owned by your trust, but all of your bank accounts are using your personal Social Security number. While you're alive, you do not get a separate tax ID number. You use your Social Security number for all tax reporting purposes when you do a living trust as long as you're alive. Now, once you pass away, your trust names one of your children to be your successor trustee. Let's make up a name, say Bill. You pass away. Bill is now the successor trustee of your trust. Now, Bill must get a separate tax ID number for that trust. That trust can no longer use mom's Social Security number. That trust and Bill, as part of the tax administration, trust administration, must get its own tax ID number, and that trust will become its own tax-paying entity until that trust is officially closed down. It might take 6 months. It might take 6 years to close that trust down. But while that's going on, the trust is earning interest. The trust is accumulating expenses. And while that's going on, the trust is filing its own annual income tax return under its own tax ID number.
Wow. Okay, let me go to Mary Ann. I've just caught your show the last several months. I really appreciate the information you're giving us. Is it better to have a will or a trust? Or are those two different identities? I'm so confused.
That's a great question, Steve. So first of all, let me remind folks that I am Tom Olsen. I'm a lawyer here in Florida. Our company is FloridaSeniorPlanning.com, Florida Senior Planning. We assist clients throughout the state of Florida, from the Keys to Pensacola. We offer a free initial consultation to talk about your estate planning. We can do that in person, over the phone, via Zoom. It could not be more simple. Together, we'll come up with an action plan. We'll mail you drafts that you can review in the comfort of your own home. And then when we're ready, we make arrangements for you to sign them. Now, Steve, she's asking, what's the difference between a will and a trust? Well, most of our clients are using simple tools to avoid probate. Those simple tools do not need a trust to avoid probate. Again, when you hear the word trust, people are talking about the same thing, a revocable living trust. Sometimes a revocable living trust can be the appropriate tool for avoiding probate. Let me give you some examples of that. If you're a young couple and you got young kids, 6, 8, 10, 12 years old, yeah, you're going to use a living trust to avoid probate, because if you, the parents, pass away, you cannot turn your wealth over to a 10-year-old child. You need to hold your assets in that trust until your children typically reach age 25. Now, if you said, Tom, I don't have any young kids, well, if your estate plan includes your grandchildren, and they're 12 and 14 years old, then a living trust would be an appropriate tool. If you own real estates in another state, if you got a vacation home in North Carolina and you got oil, gas rights in Texas, then a living trust would be the appropriate tool for you. If you've got children who are spendthrifts or have alcohol or addiction issues, or they're on governmental benefits, those are all good reasons to use a living trust. Now, Steve, some of your listeners out there right now saying, I'm confused. Tom, should I be using a will? Should I be using a living trust? Well, the good news is that Florida Senior Planning, we offer a free initial consultation. Give us just a few minutes of time. We will help you quickly figure out what would be the best action plan for you. Would it be using simple tools to avoid probate? Would it be using a revocable living trust to avoid probate? We can quickly help you figure that out. FloridaSeniorPlanning.com.
This is from Viella. She is in West Palm Beach. What are your feelings on transferring timeshares to my children?
Okay. Steve, I'm going to break the news to some of your listeners out there. And for the most part, timeshares are not an asset. They are a liability. Okay. If you think your timeshare is an asset, then go out there and try and sell it. Now, there are some exceptions out there. If you own a Disney timeshare, Disney Vacation Club, it's got value. If it's a Marriott Vacation Club, it's got value. So if you own a Disney or a Marriott, some timeshare that truly does have value, then we need to take steps to avoid probate on it. Just like we want to avoid probate on your home, we want to avoid probate on your Disney Vacation Club timeshare because it's an asset. It's got value. If you own another type of timeshare that really doesn't have any monetary value, maybe you're taking full advantage of it and you don't mind paying $3,000 a year in service fees to use your 1 week a year at your timeshare. You're loving it. Great. That's wonderful. Good for you. But talk to your kids. Tell the kids, look, this timeshare is not an asset. You're not going to be able to sell it. But if when we pass away, if you want to continue to pay $3,000 a year for 1 week's use of this timeshare, if you say yes, then we're going to take steps to avoid probate on that timeshare. Often the way I do that, Steve, on those types of timeshares that really don't have any real monetary value, the way we typically avoid probate on it is we add your children's names to the timeshare deed. So if you've got 3 kids and they all say, hey, Mom, yeah, we do want that timeshare when you pass away, make sure you ask them that question. We would make all of you as co-owners of that timeshare as joint tenants' rights of survivorship. And that's how we'll avoid probate on it. Steve, when we do estate planning for people on our questionnaire that we ask clients with standard procedure, we ask them, do you have a timeshare? Because if you got a timeshare and it's got no monetary value and you've talked to your kids and they do not want your timeshare when you pass away, we're going to put language in your will that says, I don't leave this timeshare to anybody. It goes nowhere when I pass away. And by adding that language, when you pass away, the timeshare company is not going to try and come after your kids for that $3,000 annual fee. Believe me, Steve, they do that. Even when Mom and Dad pass away, these timeshares are contacting the kids and making the kids try to believe that the kids are now responsible for that annual $3,000 manual maintenance fee. It's ridiculous.
You know, Tom, I had to ask you this question. It was such a sweet letter. This is from Millie in Lutz, Florida. And she said, I listened to all your shows. I can't stop listening to them. You have so much valuable information. I hope this is not a stupid question. I have a dog that is going to outlast me. I have 5 kids who love my dog. How do I leave my dog to one of my kids without hurting their feelings? I have to ask you that one, Tom.
Millie, that's a great question. And it's really not unusual. Our general advice to our estate planning clients is that you should leave your wealth equally to your kids. Sometimes they'll say something like, hey, I got 3 kids. One's a doctor. They got all the money they need. One's a teacher. They don't have much money at all. Hey, I'd like to leave more to the teacher child. And we still say, look, we'd like for you to consider leaving everything equal to your 3 kids, even if they have different financial statuses in life. But you can't leave a dog equal to the 5 kids. So you're just going to have to make a choice, because it's really not that much different. In the state of Florida, your pet, your animals can treat it as personal property, no different than your diamond ring or the couch or the paintings in your room. So when we do a will for people, it makes reference to a separate handwritten list disposing of personal property, things like jewelry, china, rugs, furniture, silverware, automobiles, gun collections, coins. You can put your dog right on there. The beauty of that list is that it does not need to be witnessed or notarized, and you can add or subtract from it anytime that you want to. So Millie could say, I've got 5 kids, and today I'm going to leave my dog, you can joke with the kids. Today I'm leaving my dog to my oldest son, John, but you know what? Whoever wishes me the first Mother's Day next year, they're going to be my new favorite child. I'm going to change it and leave my dog to that child. You can joke around with it, That's what I would suggest to you. I would also suggest to you, at the end of the day, yeah, dogs are nice, but at the end of the day, kids are more interested in what kind of wealth that they might be inheriting from mom and dad, and they're going to feel good knowing that at least the wealth, they were all treated equally.
Tom, I got to tell you, your show goes by so fast. The good part is Tom will be back again with us this month. We now do the show throughout Florida. Tom, tell people how they can reach your office.
FloridaSeniorPlanning.com. You can call our office right now. There's a lady up front standing by to take your phone call. 407-423-5561. I want to give that number out again, but first of all, I want to remind you that we have free booklets, Easy Ways to Avoid Probate, How to Avoid Probate on Your Home, How to Protect Your Wealth from the Cost of a Nursing Home, How to Get Free In-Home Care for Seniors. You can order those booklets by calling anytime, 407-423-5561, or going through our website, FloridaSeniorPlanning.com.
Tom, you're the best. I hope you had a great Easter. We'll see you in a couple weeks.
Thank you, Steve.
That's attorney Tom Osborne. We're going to go to break. When we come back, I've got another great guest. We'll be right back.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.